Good morning, everyone. I hope you can hear me clearly. Wonderful. So good morning. It is my distinct pleasure and my honor to welcome you all to the 5th annual iteration of the Fortis Advocatus Moot Court Competition. Thank you so much for being here with us today. We would like to first recognize and to give a special welcome to some esteemed persons who are with us here today. I'd like to recognize Justice Bakri, as well as retired Justice Thom, thank you, as well as the PS of Legal Affairs who is with us in the audience. I would also like to recognize all of the dedicated coaches who are here with us, as well as you, the enthusiastic participants who are in the audience. We have regional participants who have joined us from further afield, from Grenada and from St Vincent and the Grenadines. A warm welcome to you, as well as you, the valued members of the legal community who are joining us here this morning, you, our captivated audience, and those of you who are joining us from the live stream and watching this live on Facebook and YouTube. Good morning to you and welcome. On behalf of the organizing committee of the National Mooting Association, it is with, again, as I mentioned, immense pleasure and of course pride that I extend this warm and resounding welcome to the finals of the Fortis Advocatus Moot Court Competition. Today marks the culmination of countless hours of rigorous research, meticulous preparation, and passionate advocacy of these students. We have witnessed across the entire competition, which actually had multiple rounds. For those of you who may be unaware, they actually had to prepare a memorial brief, which is how they advanced to the semifinals. There was a semifinal round of the competition, which took place yesterday, and today we are here at the finals. So we witnessed exceptional talent across all of these rounds of the competition. There was unwavering dedication from the students, and we are thrilled to be here with you to witness the finals. This competition, Fortis Advocatus, the meaning of which is strong advocate, embodies the very essence of what we strive for in the pursuit of justice. Our aim with this competition was really to challenge the participants to not only master complex legal principles, but also to articulate their arguments with clarity, with conviction, and to really imbue in them ethical responsibility. So the journey to this final stage has undoubtedly honed their skills. It has hopefully broadened their understanding and fostered a spirit of collegiality that is vital here in our legal profession. We want to extend our sincere gratitude already to our esteemed panel of judges who are with us here today, whose expertise and guidance will be incredibly instrumental in upholding the standards of our competition. To all of our semifinalists and to our finalists, congratulations on reaching the pinnacle of the competition. Regardless of today's outcome, and this is to the finalists specifically, you have already dedicated or demonstrated exceptional talent. So you should be very proud of yourselves. Embrace this opportunity to showcase to us your skills, your abilities, your ability to learn from what you experienced yesterday, and of course, afterwards, to celebrate your achievements. We want to thank our sponsors, without whom this competition would not be possible, including the Ministry of Justice and Legal Affairs of Antigua and Barbuda, the Prime Minister's Scholarship Committee of Antigua and Barbuda, and the following firms: Court and Court Attorneys at Law. We want to recognize Cunningham Law Caribbean, as well as Daniels, Phillips and Associates, OMO Law, Chancellor Chambers, Bowen and Bowen, Roberts, Thomas and Associates, and we'd also like to thank Chasso Media, who has been here supporting us and providing this live stream, as well as the Jolly Beach Resort and Spa and the Antigua and Barbuda Tourism Authority. I'd also like to very specially recognize Mr. Maurice Merchant, who has joined us in the audience. Good morning. So with that was my welcome. We're going to have one of our directors read the case brief to you so that you understand what the students will be arguing here today. And I'd like to say, let the final arguments commence. We anticipate that this is going to be stimulating, it's going to be insightful, and we wish you, the finalists, the very best. Thank all of you for being a part of the Fortis Advocatus Moot Court competition. Let the pursuit of justice through strong advocacy continue. Thank you.
Celebrated DJ and music producer from Antigua, famous for his unique sound that blends Caribbean beats with contemporary rhythm. Known for his charisma and compelling lyrics, Vybz Skilly has millions of followers around the world and holds a near mythical status in his homeland. Yet, his life is now under scrutiny as he stands accused of orchestrating the murder of his childhood friend and longtime collaborator, Jerome Blizzard Thompson. Vybz Skilly and Blizzard rose from humble beginnings in St. John's, Antigua. They met in the Princess Anthony High School, bonded over a shared love for music, and eventually became a dynamic, powerful duo in the music industry. While Vybz was known for his larger-than-life personality and stage presence, Blizzard was known as the quieter yet equally talented half of the pair, often focused on the production and technical aspects of their music. In recent years, however, their relationship had soured. Rumors circulated in the industry about their ongoing disputes. Blizzard felt overshadowed and exploited, while Vybz was frustrated with his demands for more recognition and financial compensation. Close friends and colleagues recalled heated arguments, and some hinted that the duo was on the verge of dissolving their partnership. On the morning of May 16, 2024, Blizzard was found dead in his luxury villa in Jolly Harbor at approximately 6:30 a.m. by his housekeeper. The pathologist, Dr. Maria Smith, performed a post-mortem and determined the cause of death was blunt force trauma to the head. There were signs of a struggle in the villa with broken glass and overturned furniture. The previous day, Vybz Skilly reportedly went to the villa to discuss business matters. According to him, they argued over financial matters and the future of their musical partnership. He stated he left around 6 p.m., but the prosecution witness, Sandra Harris, claims otherwise. Sandra Harris, a longtime friend of both men and the Blizzard's neighbor, claims to have seen someone who resembled Vybz Skilly driving towards Blizzard's villa at around 8 p.m. Sandra said she was driving home in the rain and noticed a dark-colored car speeding in the direction as to where the deceased lived. The roads were brightly lit, but it was raining heavily. She observed him for at least 5 seconds, and, according to the prosecution, neighbors reported hearing loud voices and sounds of an argument coming from Blizzard's villa around 8 p.m. One neighbor, Nosy Nancy, claimed to hear Blizzard shouting, "You can't control me, and you'll never get away with this," followed by a voice she believed to be Vybz Skilly replying, "You're nothing without me." Nancy says she knows his voice because she listens to his music and watches his interviews. On May 16th, the police arrived at Vybz Skilly's home and charged him with the murder of Blizzard. His fingerprints were on the plaque that was believed to be the murder weapon. The defense countered this by stating that while he was at the house, he held the award while reminiscing on the earlier days of their partnership. As the high-stakes trial unfolded, a few of the jurors already weighed down by the intense public scrutiny, started to feel pressure intensify beyond the courtroom walls. One evening, after leaving the court, juror number 7, a young lady by the name of Cindy Shaky, said that she left Costco supermarket. A stranger leaned in close, his voice barely above a whisper, but dripping with threat, saying, "Gyal, make sure you do the right thing." She felt a chill as the man's gaze lingered and his words heavy with menace. She did not tell the other jurors, but informed the registrar of the High Court, who then informed the judge. The judge, while summing up, without mentioning the encounter, to the entire jury panel, instructed them to stick to their oath and make the decision based on the evidence heard in court. The jury returned a verdict of guilty, and the appellant now appeals on the following grounds. 1, whether the reliance on the ID evidence of Sandra Harris makes the conviction unsafe. 2, whether the circumstantial evidence relied on by the prosecution was sufficient to ground the conviction. And 3, whether the judge should have discharged the jury after the complaint was made by the juror that was brought to his attention. So those are the facts and those are the legal issues that we expect the students to be advocating on today. So we now invite the appellants, Team 101, to come forward, as well as Team 108, the respondents, to come forward and take their seats. And before we begin, I will introduce our esteemed panel for today. In the center, we have sitting magistrate, the Honorable Dane Hamilton. We have acting director of public prosecutions, Mrs. Shannon Jones-Gittins, as well as Ms. Willis Adams, Crown Counsel in the Office of Director of Public Prosecutions. So without further ado, we will now begin.
May it please this honorable court, my name is Jessica Samuel, lead counsel for the appellant. Beside me today is my esteemed co-counsel, Oceanique Joseph. We appear before you today on behalf of our client, the appellant, Mr. Adima Parker, who was convicted by the jury for the murder of Jerome Thompson. We come before you today with a heavy responsibility, but a firm conviction, to humbly submit that the verdict of this conviction is unsafe, unjust, and must be overturned. My lords and my ladies, we rely on 3 grounds of appeal. 1, the identification evidence renders this conviction unsafe. 2, the prosecution's circumstantial evidence was insufficient. And 3, the judge erred in law by failing to discharge the jury. I will be addressing the first 2 grounds of appeal, while my co-counsel will address the latter. If it pleases this court, may I please begin my submissions. Ground 1, unreliable identification evidence. My lord and my ladies, the prosecution's case rested heavily on the testimony of Sandra Harris, who claimed to have identified Mr. Parker driving towards the victim's home at approximately 8 p.m. on the night of the murder. However, this identification is flawed for several reasons. The law regarding the quality and reliability of identification evidence is well established and not in dispute. This court continues to be guided by the celebrated case of Turnbull versus the Queen, in which the English Court of Appeal outlined key considerations for assessing identification evidence. My lord and my ladies, in the interest of time, I will highlight just a few Turnbull guidelines. 1. How long did the witness have to observe the suspect? 2. What were the lighting conditions? And 3. Were there any obstructions in the witness's view? The Turnbull guidelines,
Yes,
lady?
please.
I crave indulgence. Could I please consult its memorial? What was it? Huh? Could you repeat the question, milady?
So you were just highlighting the principles that Turnbull established, so I want you to relate them to the facts.
Yes. 1 being, how long did the witness have to observe the suspect?
Yes.
Sandra Harris claimed to have identified the suspect driving towards the victim's home. She claimed to have observed the suspect also for at least 5 seconds. The second guideline, were there any obstructions in the witness's view? On the night that she observed the suspect, it was also raining heavily. And the lighting conditions, although the area was well lit, there were other circumstances surrounding her observation.
Which were what?
The speed in which the car was traveling,
Yes.
the rain, and she too was driving on that same night. Thank you, Marie.
And therefore,
And therefore, she did not have a clear view of the individual she saw.
Ask a question. Now, from what I understand from the prosecution's case, Ms. Harris was a longtime friend of Mr. Parker. Now, how does that play into the circumstances surrounding the identification?
This could have been, thank you, milady, for that question. This could have been a case of recognition and not identification, because the circumstances surrounding her observation, as we mentioned, were not credible enough. Even though she had known the suspect, her witness, her observations were fleeting. The person that she saw, she only got to observe them for a brief and limited time in a speeding vehicle at night while she too was driving. So even though she known the suspect, the circumstances surrounding her observation were not strong enough.
and you say that 5 seconds was a fleeting glance?
Yes, lady.
And how long do you need to recognize somebody that you know?
In this case, as we submitted also, even though it was just 5 seconds, her view was brief and very limited. She was also driving, so she could not have been able to focus on the road and on the suspect at the same time.
Yes,
Could I please continue my submissions?
you may.
As stated, Sandra's observations were fleeting. The view of the individual she allegedly saw was obstructed by heavy rain. And while it is not disputed that the roads were brightly lit, what benefit was this when Sandra attempted to identify an individual in a car that was speeding away while she too was driving and through heavy rain? I asked this court, did the lighting truly make a difference? My lord and my ladies, when the fog of doubt surrounds identification, it cannot be the foundation of a conviction. It was the evidence of Sandra that she knew my client and the victim for a long time. And it is arguable that it was technically a case of recognition as opposed to identification. However, we would like to draw to the court's attention the case of the Queen versus Bentley, where the court ruled that although recognition evidence may be more reliable, it still requires caution and should not be treated as automatically trustworthy. However, whether the evidence pertains to identification or recognition, we submit that it is fundamentally flawed and should not have been allowed to convict the appellant. Ground 2, insufficiency of circumstantial evidence. Furthermore, my lords, we now turn to the fragile web of circumstantial evidence that the prosecution relied on to convict Mr. Parker. A web made so thin it cannot hold the weight of a man's freedom.
Ms. Samuel, tell me what were the strands of this web that you speak of that the prosecution relied on?
Thank you for that question, my lady. The prosecution submitted that Nosy Nancy's testimony was that she heard Mr. Parker's voice coming from the victim's home on the night of the murder. Also, Mr. Parker's fingerprints were also on the award plaque found in Mr. Thompson's villa. These are the circumstantial evidence presented by the prosecution.
So it was just two strands that they're relying on?
And Sandra Harris's identification, my lady.
Yes.
None of the evidence was strong enough to prove guilt beyond a reasonable doubt. It is submitted.
You mentioned that there was more than one strand of circumstantial evidence. Are you saying that none of the evidence on its own, or none of the evidence even when taken together, you would consider to be enough?
Thank you, my lady. In this case, as we submitted, that individually, these identifications from Sandra Harris, the testimony from Sandra Harris and Nosy Nancy, and also the fingerprint placed on the plaque is not strong enough. It is individually weak. It cannot be used to convict the appellant.
So tell us about those weaknesses.
Yes, my lady. Nosy Nancy's testimony is that she heard Mr. Parker's voice coming from Mr. Thompson's villa on the night of the murder, but she only heard 4 words, my lady. The four words were, "You are nothing without me." Her identification of the voice came mainly from his music and from interviews, but she was not aware of his in-person voice in an intimate conversation. Also, another strand of evidence was...
Before you move on to another strand, and what does the law say about voice identification?
I crave indulgence, my lady. You have it. Yes, my lady. Voice identification evidence is admissible if it's not relevant and it does not exclude any other reasonable doubt.
And what is the court meant to be looking for when you're examining voice identification?
Thank you, my lady. The court should be looking for how long did the witness have to hear the voice that they heard. Were they familiar with the voice? And yes, my lady.
Question. Earlier on, you had stated that Miss, remind me of the name of that witness?
There's two witnesses.
The one who heard the voice?
Nosy Nancy.
Okay, so Miss Nancy, you stated she only heard four words. Now, are you suggesting to me that 4 words is not enough to identify a voice with which you're familiar with?
My lady, Nosy Nancy's identification or the familiarity with Mr. Parker's voice, as stated, was primarily through his music and through interviews. She was not familiar with his in-person voice, with his intimate voice used in a conversation one-on-one.
Is it that you're saying that during his interviews he puts on a voice? That he
Yes,
did not use his actual voice?
Yes, my lady, because we need to be reminded that he's an entertainer. Entertainers usually use a different persona in their music and also in interviews to keep up that image.
Yes. So you are taking us through the next strand.
Yes. The presence of Mr. Parker's fingerprints on the award plaque is neither conclusive nor suggestive of guilt. It was Mr. Parker's fingerprint, but we do not run from that because he was there. But at 6 p.m. earlier that same evening, holding the award plaque while reminiscing with a former friend about their past partnerships. That is evidence of memory, far from sinister, but speaks to the sheer history and friendship, and not to murder. My lords and my ladies,
Isn't it the evidence that there was an argument? It wasn't reminiscing. There was an argument that day.
yes, my lord, but as we submitted, Nosy Nancy, she's not sure of the voice that she heard, because it could be someone else altogether, because she's not aware of his in-person voice. Also, while in a heated argument, you also sound different to your normal speaking voice, my lord.
I wasn't speaking about the identification. We're talking about your characterization of what happened when your client would have held the object in his hand. Your client's evidence is that there was an argument, isn't that so?
Yes, my lord, but Mr. Parker, he was not at the residence at the time. He already left earlier that same evening, so it could not have been him who Nosy Nancy claimed to have heard.
On the point of circumstantial evidence and how the various strands, which may be weak on their own, could be twisted together to create something strong, how do you approach the idea that we have Sandra Harris, a longtime friend of Mr. Parker, saying that, well, I saw him going in the direction of this house, and then we have Miss Nosy Nancy, who is saying, at some point in time after the time, I heard this man's voice. What is the impact of those two things when put together?
Yes, my lady. Sandra's observation is not credible. Neither is Nosy Nancy's testimony. So we cannot use that to convict the appellant. They're individually flawed and they're very weak. Sandra's observation was done in a speeding vehicle during the rain at night while she too was driving. Also, Nosy Nancy, she does not know the voice which she heard. She cannot prove that it was Mr. Parker. Therefore, individually, both testimonies are not reliable. Yes. The defense further highlights inconsistencies with the timeline. Mr. Parker's evidence is that he left Mr. Thompson's villa at 6 p.m., whereas Sandra Harris, whose evidence we submit is unreliable, claims to have seen someone resembling him at around 8 p.m. No one saw Mr. Parker commit this crime. No one saw him at the villa at 8 p.m.
Is that really inconsistency in the evidence where you have your client saying that he was somewhere at 6 p.m. and a witness saying that I saw him at 8 p.m.? Because with that witness, you also have Nosy Nancy saying that she heard his voice at that same time. So is there really inconsistency?
Yes, milady, because those testimonies are not credible.
Continue.
No one saw him fleeing from the scene. My lords, guilt must be proven and not imagined. In the absence of corroboration or reliable recognition evidence, the Crown's timeline remains speculative. Presence does not mean participation. Opportunity is not guilt. To say that my client was there hours before, that he must have committed the crime, is to ignore fundamental requirements of proof beyond reasonable doubt. We are asked to believe possibility and not proof. In the case of the Queen versus Taylor, Weaver, and Donovan, the court held that circumstantial evidence must be so strong it excludes every reasonable hypothesis except the defendant's guilt. The evidence presented by the prosecution did not achieve this. My lord and my ladies, circumstantial evidence should not lead to a circumstantial conviction. This honorable court is not a theater for fiction. This is a temple of justice, and justice demands more than whispers in the dark and unidentified footprints from hours before. It demands clarity. It demands certainty. It demands evidence that can withstand the storm of scrutiny. Unless I could be of further assistance to this court, these are the extent of my submissions on the first two grounds. My lord and my ladies, my co-counsel will now address the third ground.
Counsel, before you sit, I want to take you back to circumstantial evidence. Isn't there more in the evidence that can be taken as a strand of circumstantial evidence? There seems to be I think there's clear evidence of motive. Can you address me on that?
Thank you, my lord. Could you please repeat your question?
There's clear, to my mind, reading the facts, there's a clear issue of motive. Wouldn't motive be a strand of circumstantial evidence that added to the identification evidence, the fingerprint, and so on, would entitle the jury to convict?
Thank you, my lord. There was no motive. There was only an argument that Nancy claimed to have heard. In friendships, in everyday life, we encounter arguments, but this is not motive for murder, my lord. My co-counsel will now address the third round.
May it please this honorable court. As stated by the lead counsel, my name is Oshanique Joseph, and I too appear on behalf of the appellant. I will now address the third ground, being whether the trial judge should have discharged the jury. And my lords, we respectfully submit that he should have. To briefly remind the court of the facts surrounding this ground, one afternoon, while outside the courtroom, juror number 7, Miss Cindy Shakey, was approached by an unknown individual. He attempted to influence her. She received a threat stating, and I quote, "Gal, make sure you do the right thing." My lords, the defendant has a constitutional right to a fair trial by an independent and impartial jury. This fundamental right must be safeguarded, as even the perception of bias or coercion can undermine a conviction, and more importantly, public confidence in the justice system.
There, you stated that there was a threat.
Yes, my lady.
Please explain to me the threat in the statement, "Make sure you do the right thing."
Okay. Thank you for that question, my lady. Given the circumstance that juror number 7, Miss Cindy Shakey, was a juror, she was approached by an unknown individual while doing her daily shopping outside Costco supermarket. The individual suspiciously approached her, leaned in close, and whispered, with an exclamation, "Make sure you do the right thing." My lords, this is ground for suspicion. More even to worry about the fact that the individual knows where she does her shopping. Given the circumstances that the individual may have known she was a juror and the key role that she plays in the verdict.
Can you point us to some case law where there was conduct that was that the court found was sufficient to be deemed interference? Can you point us to any case law on that? And then I want you to compare it to what you have in this case.
Thank you for that question, my lady. In the case of R versus Smith,
Yes.
it was held that the trial judge has discretion in deciding whether to discharge a juror or jury when juror impartiality is an issue.
What happened in that case? What were the facts?
Okay, so there was an issue of juror impropriety. Jurors were approached and bribed to make a decision.
So they had actual bribery.
Yes, ma'am.
So now tell me how we relate that to this case.
So in relation to this case, juror Cindy Shakey received the first threat. She was bribed. She was threatened, my lords and my ladies. We do not know to what extent, because the trial judge did not conduct any further inquiries. We do not know if she received a bribe. We do not know if she received monetary compensation. We do not know because the trial judge did not carry out his discretion judiciously.
No, this discretion would have been based on the information that he received from the registrar, yes?
Yes, my lady.
And what Ms. Shakey said was that she was told to make sure she did the right thing.
Yes, my lady.
What was the hoped outcome? What are you saying constituted the threat?
The fact that she was a juror, the individual could have had knowledge that she was a juror, and jurors play a key role in the verdict.
Yes, but was from make sure you do the right thing, is that instructing her to act in one way or the other?
Thank you for that question, my lady. Given the circumstances, she felt threatened. That is why she informed the registrar, who then informed the trial judge. To know the extent she was impacted, it remains unknown because the trial judge did not conduct any further inquiries. He basically dismissed her situation.
Okay, in the case of Smith, they were bribed to do what exactly?
As in the situation with Ms. Cindy Shakey, to make the right decision. And that tie had something to do with the verdict. They were jurors.
Continue.
In this matter, juror Cindy Shakey was approached by an unknown individual who attempted to influence her. She was visibly shaken, yet the trial judge failed to investigate whether this incident compromised her impartiality or affected the jury as a whole. Instead, he merely instructed the jury to adhere to their oath without making any direct inquiries. My lord and my ladies, we therefore submit that his actions were insufficient. My lord and my ladies, where justice is threatened, fairness cannot stand. Case law, including the Queen and Smith and the Queen and Mirza, makes it clear that where there is realistic suspicion of jury tampering or intimidation, the judge has a duty to investigate. My lords, in our memorials, we highlighted the medicaments test approved in Porter and McGill. It requires the court to assess whether a fair-minded and informed observer, having considered all the relevant facts, would conclude that there was a real possibility that the juror or jurors were biased. Again, my lords, it is respectfully submitted that if a fair-minded and informed observer had knowledge of the threat made to Ms. Shaky and the trial judge's flagrant inaction, indeed, they would likely find that there was a real possibility of bias. In the Jamaican case of Leng and the Queen, the Court of Appeal emphasized that failings to conduct a proper inquiry could result in a miscarriage of justice. This case also highlighted that in the absence of statutes, court rules, or practice directions, a judge has discretion in determining the procedure for addressing juror misconduct or impropriety. As in Jamaica, there is no established procedure in Antigua and Barbuda to guide the judges in this regard. However, while the decision to discharge a juror lies within the judge's discretion, this discretion must be exercised judiciously. In this case,
Ms. Joseph,
my lady,
in this particular matter, what type of verdict was required? Was it a unanimous majority? Because this is one juror we're talking about.
Thank you for that question, my lady. Despite that it was a fact of one juror, we do not know if the entire jury was infected.
What type of verdict was required?
It was the majority, my lady, sorry.
A majority verdict was required?
Yes, my lady.
Okay.
Can I proceed?
Yes, you may.
Given the circumstances, the judge's failure to investigate the juror or jury as a whole casts serious doubts on the fairness of the trial. The extent of the threat made to Ms. Shaky remains unknown, and we cannot determine whether the jury was compromised. Consequently, the jury should have never been entrusted with delivering a verdict. They ought to have been discharged, both in the interest of justice and to uphold the integrity of the verdict. My lords, fear should never sit in the jury box, because a trial by intimidation is no trial at all. My lord and my ladies, the appellants submit that the conviction of Adema Parker for the murder of Jerome Blizzard Thompson rests on insufficient circumstantial evidence and unreliable identification evidence. Sandra Harris's identification was made under poor weather conditions, raises serious doubts about its reliability. Furthermore, the prosecution's circumstantial evidence, while suggestive, fails to exclude alternative explanations for the events leading to Mr. Thompson's death. Compounding these issues is the matter of juror intimidation. The reported threat of Miss Cindy Shaky likely compromised the jury's impartiality, an essential safeguard for a fair trial. The trial judge's failure to properly address this issue or assess its impacts renders the verdict unsafe. Given these concerns, the weaknesses of the identification evidence, the circumstantial nature of the prosecution's case, and the potential for jury bias, the conviction cannot be considered safe. it is imperative that the Court of Appeal scrutinizes these failings to uphold the integrity of the judicial process and ensure justice is served. My lords, in light of the issues raised, arguments advanced, and authorities cited, it is our humble and respectful request that the court declares the appellant's conviction quashed. Unless we can be of further assistance to this court, this is the extent of the appellant's submissions.
Yes, I just have one question. Now, just going a little bit backwards to the jury bribery case. Now, you said the case was R against Smith?
Yes, my lady.
And they were told to make sure they do the right thing?
In the alignment with juror Cindy Shaky, they were told to make the right decision.
Those were the facts of Smith?
Yes, my lady.
Do you have a citation for that case?
Yes, my lady. The citation for that case, thank you, is the English and Wales Court of Appeal, Criminal Law 2806 of the UK.
Say that for me one more time.
The English and Wales Court of Appeal, Criminal Law 2608 of the UK.
What year? What year is the case?
Pardon me? 2005, my lady.
Okay, well, give me 1 second, please. Okay, thank you.
Counsel, I want you to state for me succinctly, what is the test, what's the discretion the judge had to exercise in dealing with this issue with the juror?
Thank you for that question, my lord. Firstly, the judge should have informed not only defense counsel, but the prosecution's side. Secondly, the trial judge should have conducted an inquiry as to the extent of the threat made to Miss Cindy Shaky. Thereafter, a decision would have arisen as to whether to discharge Miss Cindy Shaky alone, the entire jury, or none at all. Does that answer your question, my lord?
It doesn't really. You've listed what he should do, but in exercising his discretion, the trial judge has a wide discretion here. How should he exercise his discretion, whether or not to discharge the juror, or, depending on the results of whatever facts he has, discharge the entire jury?
The trial judge should have investigated. He discharged the jury. He discharged the claim made by juror Cindy Shaky and instructed the jury to adhere to their oath. Although he did something in the situation, he did not exercise his discretion judiciously. And I say so because he did not make any further inquiries as to even what the threat was about or if she spoke to anybody else.
All right, counsel. All right.
Does that satisfy you, my lord?
Counsel, I will be frank. I'm not satisfied. Isn't it that the test is whether the jury is subjectively or objectively biased? How do you get to that determination? That's at the heart of this ground of appeal.
I crave indulgence, my lord. Lord, the trial judge did not exercise his discretion judiciously. And I say so, once again, because he did not conduct any further inquiries as to the threat made to Ms. Shaky. Defense counsel was not informed of the threat until the trial had concluded. This cannot no way be considered a judicious exercise of discretion.
And are you saying that by not making any further inquiries, we'll just never know how
We will
deep
never
things
know
were?
because he did not question Miss Cindy Shaky to find out what the threat was about. He did not even ask what the threat was about. He did not know the extent of the threat. He just stated to adhere to your oath.
Okay. Thank you.
Thank you, ladies. Are there any further questions, my lordship? Thank you.
No, no.
Good morning.
Good morning.
May it please this honorable court, my name is Imai Guinness and I'm lead counsel on behalf of the respondents. Appearing with me this morning is co-counsel C.C. Lewis. The appellants have provided 3 grounds of appeal. The first ground being whether the reliance on the identification evidence provided by Sandra Harris renders the conviction unsafe. The second ground of appeal speaks to the prosecution's reliance on the circumstantial evidence and whether it was enough in grounding the conviction. The third ground of appeal speaks to the judge's discretion in not discharging the jury after the alleged jury tampering which took place. I will be making submissions on the first ground of appeal and co-counsel the third ground of appeal. The second ground of appeal will be split between co-counsel and lead. If it may please this honorable court, I would like to continue with my submissions.
Proceed.
As mentioned earlier, the first ground of appeal states whether the reliance on the identification evidence provided by Sandra Harris renders the conviction unsafe. The respondents submit no, for 3 reasons. Firstly, Sandra Harris's identification evidence is in alignment with the guidelines established in the Queen against Turnbull 1977 from the British Court of Appeal, which is applicable under our common law jurisdiction. Furthermore, in most recent times, our Eastern Caribbean Court of Appeal has applied the Turnbull guidelines in our very own Carlton versus Bedminster case of 2010. My second point, the facts of this case show that this is recognition, which is stronger than identification by strangers. And thirdly, independent corroboration occurs with the voice identification provided by Nosy Nancy, bolstering the credibility of Sandra Harris's recognition. When we recall the facts of the Queen against Turnbull, the case outlines the warning which should be given to the jury that an honest witness can make a mistake in identification. Turnbull also outlines factors to observe when analyzing the quality of an identification evidence, qualities such as lighting, distance, duration of observation. When we compare the conditions under which Sandra Harris made her identification, they are in alignment. Sandra Harris saw the appellant driving, speeding towards her for at least 5 seconds in heavy rain in a well-lit area as he drove a car with no tint.
No,
And
sorry,
you
if
say
I
that
meant to...
so easily. Sorry. The speeding in rain, aren't those things that would hinder the identification evidence?
No, my lord.
Why?
According to Turnbull guidelines, she was in a well-lit area, so that accounts for the lighting. The distance and proximity of the vehicle was accounted for due to the fact that this appellant was speeding towards her.
Okay, 1 second. Was Miss Harris not also driving her vehicle?
Yes, she was, my lady. However, that does not dispute the fact that Sandra Harris's focus must be on oncoming traffic, the traffic in front of her and that behind, attaching equal weight of focus.
Sorry, can you just easy
Sorry.
pace? Yeah. So can you repeat that for me, please?
I said yes, but it does not dispute the fact that Sandra Harris had to have been focusing on oncoming traffic, the traffic in front of her, and the traffic behind of her as a responsible driver.
Okay. Continue.
Sandra Harris's identification was in alignment with that of Turnbull's guidelines. Again, she saw the appellant for at least 5 seconds in a well-lit area with no tint. Furthermore, the facts of this case is grounded in the recognition. Sandra Harris has a long-standing familiarity of the appellant for that of 15 years. Therefore, it bolsters the credibility of her identification. And when we look at the legal authority, Beckford versus the Queen, 1986, where it is said, in cases of recognition where the accused is well known by the witness for an extended period, the true test might be that of credibility rather than an honest witness making a positive yet mistaken identification. The respondents are submitting that Sandra Harris is a credible witness, as this identification took place in innocence. She merely saw her friend speeding by and was able to account for the fact that she saw him when the news broke on May 16th. Thirdly, independent corroboration occurs which bolsters the credibility of Sandra Harris's identification.
Let's go back to the visual identification, because you keep saying that it aligns with the Turnbull case. In this case, in your case, she saw him for 5 seconds. Some may say that's a fleeting glance. What do you say to that?
I do not agree, especially because the identification is grounded in recognition. Strangers who merely see or saw each other. This is someone who's known the appellant for at least 15 years, and thus the 5 seconds was more than substantial in grounding her identification. Furthermore, recognition.
Now, what would you say to the question that can be considered implausible that she had the full 5 seconds to have this man in her view where he was speeding and she was also driving?
I would say that Sandra Harris was driving home, and a black car speeding in heavy rain at nighttime captured her attention. Furthermore, she wanted to see who could have been driving like this at this time of the night in heavy rain, and thus in her focus on the driver, she identified or furthermore recognized the appellant.
So you're suggesting that she was not focused on the road and her own driving?
I'm saying that she was focused on all of the factors of the road: oncoming traffic, the traffic in front of her, and the traffic behind of her.
Counsel, do you admit that the heavy rain is an obstruction?
I admit that the heavy rain could cause an obstruction, but given the other factors in which she made her identification, and furthermore, the recognition, it accounted for the credibility of her identification.
Yes.
Yes.
Independent corroboration occurs which bolsters the credibility of Sandra Harris's recognition. Nosy Nancy, a long-time and dedicated follower of Vibe Skinny, heard this man's voice shouting through the neighborhood after 8 p.m. when Sandra Harris recognized someone who looked like the appellant driving towards the business residence at around 8 p.m. Therefore, these two witnesses are able to identify the fact that the appellant was at or around the business residence the last time he was seen alive. I will now move on to the second.
Wait. Let's speak about the circumstances under which that identification of his voice was made.
The voice identification took place because there was a confrontation between the appellant and the deceased. A loud one, to which many neighbors recall hearing loud voices and shouting. And because Nosy Nancy is a neighbor of the deceased, she was able to identify the voice of the appellant shouting. And furthermore, which I will touch on in my submission on the second round of appeal. Justice of Appeal, in the case Neville Barnes versus R, states that the greater the familiarity of the accused, the less words need be spoken. Therefore, those 4 words of "you're nothing without me" was more than substantial in grounding Sandra Harris, Nosy Nancy's voice identification.
Also, why are you saying that someone who does not know the speaker, who's merely heard the speaker on TV, on the radio, that 4 words can ground an identification, a voice identification?
once there is a high level of familiarity, which has been established with Nosy Nancy and the appellant.
Can you point me to the evidence, please?
Nosy Nancy is a long-time follower of the appellant. She listens to his music. She also listens to his interviews and follows him on several social media platforms. Therefore, the frequency to which she hears the appellant's voice is not by mere coincidence or just hearing his music while you're along, but because she had intention of following this man, listening to his voice in his music and his interviews. That accounts for the credibility of the familiarity in which Nosy Nancy has of the appellant.
But you would admit that she's never had a conversation with him.
Yes, I do admit, however, that does not dispute the fact that she's familiar with the appellant's voice.
She is familiar with a voice by the applicant. How do you account for the fact that he is an entertainer?
Well, he is an entertainer, yes. However, again, the variety of exposure in which he has to his voice, not only through his live performances, but recorded music, live interviews, as well as reels or stories he may post on Instagram, that accounts for her exposure to the different types of voice if he may use them. Furthermore, the facts of the case do not indicate that the appellant uses different tones and inflections based on the situation in which he is.
Okay, continue.
The case that you referred us to for the voice identification that said where it's a case of recognition that it could be fewer words.
Yes,
what are
ma'am.
the facts of that case?
In Neville Barnes,
Yes. How many words were spoken there?
in Neville Barnes, there were 5 words spoken by the accused.
Yes, and what the court held.
The court upheld that the familiarity of the witness and her exposure to these brothers, because it was the brother brothers, and her exposure to the brothers and the frequent interaction she had with them accounted for the fact that her voice identification was credible. Furthermore, in Rohan Taylor versus Rohan Taylor versus R, that case is grounded on voice identification, provided by the sole witness, Miss Dorothy Johnson, who has had frequent exposure to the accused, Mr. Hyde and Mr. Barrett. She heard them conspiring to hide a murder in her backyard. And the trialing judge said that in order for the evidence of a witness that he recognized an accused by his voice to be accepted as cognate, there must be, we think, evidence to the degree of familiarity the witness has had with the accused. Miss Dorothy Johnson had known the accused for over a year and some months, having several interactions and exchanges with them in the bar and cafe at which she worked.
Those were personal interactions, not over social media.
Agreed. However, that does not dispute the fact that Nosy Nancy as well has this familiarity, as she's not a new follower of the appellant. She has been following his career from a very long time.
Would you not agree with me that sometimes persons do in fact sound different in recordings than they do when they are speaking face to face?
I do agree, my lady. However, to reiterate, these facts were not presented in the case. It is not indicated in any way that the appellant provides different personas and inflections
No,
based.
I'm not speaking about different personas. I'm speaking about the act of listening to something through technology itself, that sometimes that does not give the best indication of what someone sounds like on a day-to-day basis in a live scenario. What do you say to
I
that?
agree. However, like I said, the exposure and the variety of her exposure accounts for her credibility in the voice identity.
Okay, please continue.
The second ground of appeal refers to the prosecution's reliance on the circumstantial evidence and whether it was substantial in grounding the conviction. The Blackstone's criminal practice, first, defines circumstantial evidence as the evidence of relevant facts, facts from which the existence or non-existence of facts in issue may be inferred. Furthermore, in the DPP versus Kilbourne 1973, Lord Simon said that the circumstantial evidence works cumulatively in geometrical progression, eliminating other possibilities. We have 4 powerful strands to our cord of circumstantial evidence. The first being the voice identification, which I elaborated on earlier. The second, the evident lie the appellant told about the time he left the Blizzard's residence. The third, the motive. And the fourth, the fingerprints found on the murder weapon. As mentioned, I elaborated on the voice identification earlier, so I will move on to the lie. When asked the time that he left the Blizzard's residence, the appellant stated 6 p.m. However, 2 witnesses have provided evidence as to otherwise. Nosy Nancy, seeing the appellant drive toward the Blizzard's residence at around 8 p.m., and, my apologies, Sandra Harris, seeing the appellant going towards the Blizzard's residence at around 8 p.m., and Nosy Nancy hearing his voice after 8 p.m. Furthermore, the case, the Queen against Lucas, stated that a lie can only support an inference of guilt if it is a deliberate untruth, relates to a material issue, and is not told for reasons such as shame or guilt.
Yes, so let us apply Lucas to the facts.
Firstly, the lie is deliberate. The appellant could have said that he left the Blizzard's residence at 8, but he said 6, sorry. And this is out of a realization of fear and guilt. Fear that it is made known that he killed the appellant. Third, the material issue is the time that he left. This time is crucial in grounding and placing the appellant to the Blizzard's residence at around the time of his death. He was the last person to have seen him alive. Fourthly, there is accurate evidence. There is evidence that occurs that goes with the accuracy of his lie, and that would be the testimony provided by Sandra Harris and Nosy Nancy. Co-counsel will be presenting on the motive and the fingerprints found on the murder weapon, and she will be making submissions on the 3rd ground of appeal. Thank you.
Counsel, before you sit, address me on whether or not the lie, aren't there other reasons an accused man may lie?
You're asking me if there's another reason why the appellant...
Address me on that issue. You're assuming that the lie is deliberate. The accused may have deliberately lied because he felt he doesn't have a good alibi.
Oh, okay.
There can be many other reasons for him lying. Address me on that, please.
I agree with you, my lord. However, it does not dispute the fact that he lied, and the prosecution is allowed to rely on a lie in the court. Regardless of the issues, regardless of the reasons for the lie, the fact that he told the lie and there is an inconsistency, the prosecution is allowed to rely on it as evidence.
That may be so. But what's the law in relation to lies, generally?
The Queen against Lucas, as I stated earlier, regarding the lie which can be told out of a realization of guilt relating to a deliberate issue. Furthermore, I crave your indulgence. Furthermore, it was also held in good way against the Queen that when a lie is told by the accused, the prosecution can rely on it regardless of the reasons as to which he lied. The mere fact that he lied was more than enough for them to rely on it in the court. Thank you.
Good morning.
Good morning.
May it please this honorable court, my name is Cece Lewis, co-counsel for the respondent. As previously mentioned by my co-counsel, Ms. Guinness, I will be presenting on the second half of issue 2 and issue 3, which centers around whether the circumstantial evidence was enough in grounding the conviction and whether the trial judge was correct in his decision by not discharging the jury. If it may please this honorable court, I'd like to continue with my submission.
Please continue.
The circumstantial evidence against the appellant, Edema Vibe Skilly Parker, is overwhelming and sufficient in support of the jury's verdict of guilt beyond a reasonable doubt. As previously mentioned by my co-counsel, the prosecution contends that the combination of the eyewitness testimony, the appellant's lies, opportunity, motive, and forensic evidence established that the appellant killed the deceased, Jerome Blizzard Thompson. In Blackstone's Criminal Practice 1998, it states that in the prosecution of murder, animosity between the accused and the deceased is not only expressive of a malicious mind, but also serves as evidence to the fact that the accused committed the crime.
So what's the evidence of motive in this case?
The evidence demonstrates that the relationship between Vibe Skilly and Blizzard had significantly deteriorated due to ongoing disputes over recognition and financial compensation. Blizzard, who plays a key role in music production, reportedly felt overwhelmed and exploited within the partnership, believing he was not being fairly credited for their success. Meanwhile, the appellant expressed frustration over what he perceived as Blizzard's increasing and unreasonable demands.
So this disagreement is what we're bringing up to the level of a motive for murder?
Yes, milady. Close friends and colleagues recall heated arguments between the two over an extended period of time, which some would suggest that the duo was on the verge of dissolving their partnership. This tension creates a volatile atmosphere that can set the stage for violence. On the night of the murder, a credible witness, Nosy Nancy, testified that she heard a heated argument between the appellant and the deceased. Blizzard was overheard shouting, "You can't control me, and you'll never get away with this," to which the appellant responded, "You're nothing without me." This statement is particularly damning as it not only suggests the intent to dominate, but also demonstrates an underlying resentment strong enough to escalate into violence. The fact that the appellant and the deceased were having another heated argument on the same matter of recognition and financial compensation again, the fact that this statement was uttered during the final moments before Blizzard was last heard alive, supports the prosecution's case that this argument culminated in murder. The appellant has a well-known history of short-tempered outbursts, particularly when dealing with matters of recognition and control. This pattern of behavior aligns with the prosecution's argument that his frustration with Blizzard, finally reached its breaking point on the night of May 15th of last year. Moving on to the forensics, the forensic evidence further strengthens the prosecution's case and draws a clear line of the connection between the appellant and the murder. The cause of the death was blunt force trauma to the head, and the murder weapon and award plaque was discovered near the body of the deceased. Notably, the appellant's fingerprints were identified on the plaque. While the defense contends that the appellant may have touched the plaque during an earlier visit, it does not preclude the prosecution from relying on this crucial piece of evidence to establish that the appellant's involvement in the crime. The defense's explanation must be The defense's explanation must be considered alongside these undisputable facts. The plaque was located near the body, in a room where there was visible signs of struggle, including broken glass and overturned furniture. The cause of the death matches the type of injury the plaque could have caused. The inference raised by the defense is not of fact, but one of credibility. An issue the jury is to resolve. The appellant's explanation, I crave your indulgence.
Sorry, can you point me to the evidence that the plaque was found near to the body?
It's stated in the fact pattern.
Page 1, line what?
Where exactly?
I crave your indulgence. Sorry, my lady. Fault of the tongue. Slip of the tongue, no fault of the mind. plaque was not near the body at the scene of the crime.
Okay, please continue.
Thank you. The inference raised by the defense is not one of fact, but one of credibility, an issue that the jury is to resolve. The appellant's explanation for the presence of his fingerprints on the murder weapon lacks independent corroboration and is inconsistent with the surrounding circumstances.
Well, we've just admitted that the plaque was not found near to the body. There's no evidence that there was blood found on the plaque. So how is it inconsistent? Is there even any evidence that that plaque was in fact the murder weapon?
The blunt head force trauma aligns with the type of injury the plaque could cause. So,
Well, counsel, I think the short point is that if there are more than one alternative, shouldn't the court come down and favor the version of facts that benefits the defendant?
with respect, my lord, under McGreevy versus Director of Public Prosecution, the jury should only acquit if the evidence allows for a reasonable alternative explanation. While the defense suggests other inferences for the fingerprints, they're speculative at best.
What's speculative about this? Two persons that know each other since secondary or primary school. They're in business together. They visit each other's homes. They have awards. Is it speculative for one or both persons' fingerprints to be on an award?
Well, there was no sign of any other identifiable prints on the award plaque, just the appellants. But if we are to disregard the fingerprint evidence, we still have other circumstantial evidence, including with the eyewitness testimony from Sandra Harris, who placed the appellant near the scene of the crime at a crucial time, the neighbor who heard the argument, consistent with the ongoing disputes, both the appellant and the deceased.
You're going a little fast, so we're not getting the point.
My apologies.
So if we disregard the fingerprints, what do we have left?
We still have the other pieces of the inference, Sandra Harris's testimony placing him at the scene of the crime at a crucial time.
Sandra placed him at the scene?
Around the scene of the crime at a crucial time.
Yes.
And neighbor Nosy Nancy overheard the argument, which is consistent with the ongoing dispute between the appellant and the deceased, additionally with a long-standing dispute and hostility, and the two establish which also establishes a strong motive, while the appellant's lies weaken his credibility. May I continue?
Yes.
The evidence clearly shows that Vibe Skilly had the motive, opportunity, and means to commit the crime. His hostility towards Blizzard, the forensic findings, and multiple witness accounts all point to his guilt beyond a reasonable doubt. Even without direct evidence, the facts align in a way that means no reasonable alternative explanation. While that established, I now turn to the issue 3.
I know you have to get to your other issue, but before you leave, if it is that those strands for the visual identification and the voice identification are weakened by what the defense has highlighted, what do you have left?
I beg your pardon?
If the voice identification and the visual identification, if those strands are weakened by the things that were highlighted by the appellant, for example, the fleeting glance, the fact that she never heard him in person, if those things are weakened, what do you have left?
I crave your indulgence. Can you please repeat your question, milady?
said, if we put aside your fingerprint, the forensic evidence, that you still have your voice identification, you still have your visual identification, yes? I'm saying, if those things are weakened by the points raised by the defense, what do you have left?
Well, the sole fact that Adima Vibes Killy Parker was the last person to see Blizzard alive, and the fact that the circumstantial evidence is meant to be put together to point towards this strong this inference rather than be looked at in isolation.
You can go on to your final point.
Thank you, milady. This court should find it in favor of the respondent for the reason that the trial judge properly exercised his discretion. The incident involving juror Sidney Shaky did not compromise trial fairness, and the judge's measured response was sufficient enough to uphold the integrity of the proceedings.
Counsel, what's the judge's duty if an issue with the juror or the jury arises?
In the matter of jury tampering, the judge is to use his judicial discretion, guided by the need to uphold the integrity and continuity of the trial. This principle is well established in Campbell versus R, where the Privy Council held that a judge must carefully assess a situation before determining an appropriate response.
So how does he assess the situation?
I beg your pardon?
How would he assess the situation? The judge is told something by the registrar, and it appears to me that the evidence is suggesting that all the judge did was give directions to the jury at the close of the case. Is that what the judge ought to have done?
Though I can admit an investigation would have been seen as a careful and ethical response to the situation, his decision by not holding an investigation is just. I crave your indulgence. My apologies. An investigation may have introduced unnecessary speculation and cast undue suspicions. By declining to pursue the matter further, the judge preserved the objectivity of the jury, avoiding inflaming the incident and rightly concluding that the statement was ambiguous, devoiding any clear connection to the trial, did not warrant any disruption.
Now, may I ask a question? The statement may have been ambiguous, but how will we should know how Ms. Shaky interpreted it? Suppose she thought that that clearly meant you must vote guilty.
Going back to the situation, let's look at the severity in Campbell versus R versus the severity in this case.
Okay.
Severity, sorry. In Campbell versus R, the jury tampering was extreme. A fellow juror offered the others $500,000 to influence their verdict. This was a direct and explicit act of bribery, which the Privy Council determined was a material irregularity. Not only were there multiple jurors directly approached, but there was an influence tied to a specific outcome, which clearly rendered the trial unsafe. The ruling clarified that a mere reminder of the jury's oath was insufficient in a case of severe tampering. But unlike Campbell versus R, where the jury was directly approached with a bribe, Ms. Shaky merely heard a vague statement while leaving Cospro's supermarket. "Gyal, make sure you do the right thing." This comment did not mention the case, the defendant, or any expectation of a particular verdict. The statement was ambiguous and could have been interpreted in many ways, including a general encouragement to act ethically. The setting of the approach was ambiguous. She was walking outside of Costco supermarket. Nothing of this incident was tied to the case, the present case at all.
Well, counsel, don't you feel that the trial judge would not have known or would not have been able to come to a judicial decision regarding those elements without, at the very least, speaking with the juror?
My lord, can you please repeat your question?
I'm asking you if you don't consider that the trial judge would not have been able to come to a proper appreciation of the facts. In order to exercise a discretion, the judge must have facts. He must find facts, hear some degree of evidence. So shouldn't he have spoken with the juror or gotten those details from the juror herself?
Well, based on the information that he was given from the registrar, the fact that Ms. Sydney Shaky reported the matter to the registrar showed that she was going according to conduct and she was showing transparency. And with the incident, there was no mention of any financial inducement, oppression, or threat to the case. So he didn't see, so by analyzing the situation, he saw no need for...
Doesn't your brief expressly state that the juror felt threatened?
Yes, my lord, but if it was a situation that she felt severely threatened to the point where she couldn't make a proper decision, then she would have excused herself from the case.
Is she allowed to do that? Could she just say, I don't want to do this anymore?
It's obviously more complicated than that, but in the case Campbell versus R, where a juror's son was approached, was threatened, she removed herself from the proceedings because for the protection of herself and her family, seeing that the situation was getting too, my apologies, the situation was getting too heated.
You see, counsel, the essence of the point is that the defendant is saying, I never knew anything about this. This never rose. Counsel was not informed. The trial judge never spoke to the juror or had someone speak to the juror and conduct an investigation as to what the juror actually felt, what actually happened, so the trial judge could make up his mind as to whether or not this is immaterial or something substantive which may require the discharge of the jury or further investigation. What would you think? Would you say that what happened here was appropriate?
Yes, my lord, because the legal system needs to balance protecting the integrity of the trial and ensuring that the trial is not unnecessarily disrupted by minor or speculative concerns. There was no evidence that her conscience was swayed in any way. So if he had discharged the jury based on such an ambiguous remark, lacking context, intent, or clarity, it would imply that the mere possibility of outside influence without evidence or of actual prejudice would be enough to undermine the proceedings of a trial.
Okay, so I have two questions. Sorry.
It's not so much about the discharge, but the lack of the investigation.
I understand. May I continue?
No, I was asking you, well, I think, could him not asking any questions at all, we'll never know how deep that ran, the threat ran. Could you admit that?
Yes, my lady, I can admit that.
And the cure? What was the cure?
He reminded the jury of their oath and told them to make a decision based on the evidence presented.
And that was sufficient?
I would say that it's sufficient, milady.
Very well.
May I continue?
Yes, you can.
Yes, ma'am.
In conclusion, the accumulation of circumstantial evidence, strong motive forensics, and eyewitness testimony leaves no reasonable doubt that the appellant committed the crime. This honorable court should uphold the decision of the trial judge, since there was no real risk of prejudice, either conscious or unconscious. The trial was conducted fairly, and no miscarriage of justice occurred. Therefore, the respondent respectfully submits that the appeal should be dismissed, if it may please this honorable court. Thank you.
All rise. This court now stands adjourned for 20 minutes.
Okay. The, the panel has deliberated and we're going to announce the results now, and afterwards we have a few comments. We found that the appellants are successful today, and the best speaker was Ms. Samuel for the appellants. In terms, you want to go comments first?
As it relates to I'll start with the things that I enjoyed overall for everyone. And I should say, like, firstly, you should all give yourself a big round of applause and a pat on your back, because what you have done today is not easy. It's not easy at all. And you were all very, very well. I'm going to say excellent. You have excellent futures ahead of you if you do intend to go into advocacy, and you should be very, very proud. Overall, most had very good posture, maintained very, very good eye contact. I will start with the respondents. So council number 1 for Ms. Janice. At certain times you did speak fast, and it was hard to keep track of what you were saying. But I will say that you responded to questions very well. You did sometimes toe the line between when to concede a point and when to keep going, but I will say most of the times you did concede when you had to. As for Ms. Lewis, you also succumbed to speaking quite fast at certain times. I think even after you were told to slow down at once, and it could have just been nerves. You did not concede points well, though. There were times when it would have been best for you to concede a point and go on, but you did establish very good knowledge of the material, and you also maintained very, very good eye contact and energy. Ms. Samuel, you were very poised, and you spoke in a clear and concise manner and at a good speed. I liked the fact especially well that you did take the time to contemplate each question before you answered, and you also maintained really good eye contact equally amongst the judges. Miss Joseph, sorry, let me find my note. You're very firm, and you knew when to stick to your point. There was the one question, though, when Ms. Jones-Gissens asked you about the verdict that was required, and you said a majority, and that's not the case in a murder. It would have had to have been unanimous, but you did show very good knowledge of the material. You're engaging to listen to, and overall, you guys did a very, very good job, all 4 of you. So please give yourself a round of applause.
Okay, I'm not going to make personal comments. I'm going to make general comments about everyone's performance. I also have to say, this is a job well done. I could not see myself being able to do what you did back when I was in sixth form, honestly. While we were deliberating, I was thinking about myself and the other person who, in sixth form, who's an attorney. I was like, we wouldn't be able to do this. So please congratulate yourselves. Keep up the good work. right? Now, one of my concerns, let me start with that one, was that I really wanted to see your ability to admit and move, or admit and deflect. That's something that anyone who's going to be serious about being an attorney, you need to be able to say, okay, this is not in my favor, and accept it right away. It makes your argument stronger to be able to accept something, admit it, move on, or show what else is stronger in your argument. I thought that once or twice it appeared as if there was a feeling that you needed to argue with the bench. Arguing with the bench is never good. It's something that you do when you have to. It's not a good thing, right? You have to know when to stick to your point, when to take that the bench is not with you, and when to move on. I think that in terms of, well, it was obvious we didn't let you go on with your scripts, right? This is meant to be, you're in the Court of Appeal. The Court of Appeal would have read your submissions, would have read all your authorities, if there's anything new that they didn't know. The Court of Appeal would have known the facts. The advice, a bit of it, I don't know if it's advice or it's just a bit of something that was handed down to me by my father. When you go in front of an experienced panel, a good judge, you have to go thinking that they know everything. Someone on the panel has read everything. They're ready to question you. So you have to be ready from the jump to be questioned. And I found that you were a bit flustered when we started stopping you. I don't think we really marked you down that much for that, because you are A-level students, you're not lawyers, you haven't started any advocacy training. But I have to commend the fact that when you ask questions, each one of you turn to your co-counsel. That's a very important thing. When you have counsel at your side, you may not know everything, right? You may not hear what the judge is saying. And you should always take the time to consider the question, consult if you have to, and then answer. I think the last comment is, is that I want, in terms of knowledge of the facts, your brief is your brief. You don't add to the facts. However, the facts are not just what is said, but the facts is also what is not said. The absence of certain things. For instance, the absence of a conclusive statement that the award was the murder weapon. That's a very important thing to be able to tease out of the facts. I really was waiting for the appellants to raise that issue. And the appellants, you didn't really raise it. And there was some other things, when you're confronted by these kind of fact patterns. At A-levels, you're not going to get this long and involved a fact pattern. But sometimes it's important to bear in mind what hasn't been said or what isn't there. And if you go on in mooting competitions, that's very important. Because sometimes you can have the best moot speaking about everything that's obvious on the facts. And then the opposing side will will bring up something that is just not said, and it's a very important omission from those facts, and that can be the difference between the judges saying that you have a greater command of the facts and a greater ability to deploy some bits of your legal knowledge that persons may not have expected, right? But overall, a very good job, and congratulations to the winners.
When you're the last speaker, you get to say, I endorse the comments of my colleagues. So I will say that. But also, I wish to add that I was very impressed by the speakers, all on both sides. At times, I forgot that you were sixth form students. So I had to temper myself in terms of the questions that I'm posing to you, because you were doing so well. I also wish to just piggyback on something that Mr. Hamilton said in terms of arguing with the court. The second speaker for the appellants, you know, when you're addressing the court, you have to be mindful of the manner in which you do so. And there was a point where you asked the bench a question, and it was the question itself and the way in which you asked it, that it could be seen as a bit disrespectful. So you have to be mindful of things like that. But overall, you guys showed a very decent understanding of the law and how to apply it to the factual situation which you were given. And your performance is also, I guess, a testament to the hard work of your coaches. So commendations to them too. And if it is that you wish to continue, I really hope that you do continue, if law is something that you really are interested in, that you continue to participate in competitions such as this, and you can only grow and get better. So thank you.
Let me add one more thing. Any of you who wish, if your goal is to become attorneys, practice the criminal law, please. We need criminal lawyers. Practice the criminal law. It's where you learn the rules of evidence. It's where you get your skills as an advocate. Right? Right? But congratulations again.
Yes. Thank you.
Good afternoon, everyone. May it please this honorable court, my name is Andrena Athel de Souza, one of the directors of the National Mooting Association of Antigua and Barbuda. And it is an absolute honor to stand before you at the close of the 5th annual 2025 Moot Court competition. Now first, before I begin wrapping up the competition, I would like to recognize some very important guests this afternoon. Justice Bakri, retired Justice Keith Thom, Permanent Secretary in the Ministry of Justice and Legal Affairs, Mrs. Hildred Simpson, Chairman of the Prime Minister's Scholarship Committee, Mr. Maurice Merchant, and Ms. Alketz Joseph of Court and Court Attorneys at Law. Thank you so much for your support and being here for our teams this morning. Other esteemed members of the legal fraternity, our distinguished judges, valued sponsors, coaches, directors, and audience, thank you for your presence and your continued commitment to nurturing excellence in legal education in our region. Now, 5 years ago, the National Mooting Association embarked on a mission, and that was to contribute to the legal minds of Antigua and Barbuda. Today, I am proud to say that we have remained committed to that mandate and expanded our reach throughout the OECS. For the National Mooting Association, this is more than just a competition. It is a commitment. It is our commitment to nurturing legal minds who will someday become advocates, judges, and policymakers. It is a signal that we believe in investing in our youth, in their brilliance, and in the future of justice across the Caribbean. At this juncture, I want to highlight this year's competitors, which were represented by 3 outstanding institutions, one from Antigua and Barbuda, from Grenada, and from St. Vincent and the Grenadines. So we had the T.A. Marichaud Community College of Grenada, the St. Vincent and the Grenadines Community College, and the Antigua State College. Give them a round of applause, please. They did an absolutely amazing job. Now, I have to speak to each team, and as the judges pointed out today so rightfully, both in the semifinals and finals, your performances over the past 2 days were at a particularly high standard. They have proven that our region is rich with young people who are not only intellectually capable, but poised, articulate, and deeply thoughtful. You came prepared, you stood tall, and you argued fiercely and fairly. You have indeed made your schools, countries, and your supporters very proud. Now, of course, our students could not do this without the support of their coaches. And each and every year, we extend invitations to the legal fraternity to coach our students into excellence. And every year, without doubt, we have their commitment. To Mr. Arthur Thomas, to Miss Akila Southwell, who would have coached our winning team, and to Mr. Zachary Phillips, we say thank you. Now, the Directors Committee, our members also double as coaches, so we have, more work than normal. To Mr. Curtis Cornelius, who would have coached our second place team, and to Miss Janice St. Romain, I want to thank you so much and also for all of your work. To our competition liaisons, because of course we have to organize this competition now throughout the region. So from Grenada, Miss Jasmine Redhead, and our coaches from Grenada, Miss Danish Harford, Miss Cherise Noel, and Miss Crystal Braveboy Shatteram. Now, our competition liaison and coach from St. Vincent, Mr. Adrian Odell. We say thank you so much for guiding these students with passion and precision. Your mentorship has definitely left a lasting impact. Now to our judging panels. When we embarked on this competition about 5 years ago, we said that we wanted it to be of a particularly high standard. And to do this, we needed an esteemed panel of judges. So you play a valuable role in leaving an indelible mark on our teams every single year. So for the semifinals, we say thank you to the Honorable Andrew Mighty, Mrs. Maureen Hyman Payne, and Miss Rashida Jonas, and Mr. Paulio Williams. And for the finals, today, the Honorable Dane Hamilton, Mrs. Shannon Jones-Gittins, Acting Director of Public Prosecutions, and Miss Rillis Adams. We are incredibly grateful every year for your time. I crave your indulgence. Yes, we are incredibly grateful for your time, your wisdom, and the example you set for the future of legal professionals. To our sponsors, because while the Directors Committee, we have energy, we have the logistics, and we have the systems in place, we also need extra resources to ensure that we execute this competition. So we want to say thank you for your investment in justice and legal education. The Ministry of Justice and Legal Affairs and the Attorney General, the Honorable Sir Steadroy Benjamin, the Prime Minister's Scholarship Committee, and the Chairman of the committee, Mr. Maurice Merchant, Court and Court, Attorneys at Law, Daniels Phillips and Associates, Chancellor Chambers, Cunningham Law Caribbean, Bowen and Bowen, OMO Law, Roberts Thomas and Associates, and Chaso Media, also the Antigua and Barbuda Tourism Authority, and the Jolly Beach Resort and Spa. We also want to say a very special thank you to Shirley Mayers at Sunrise Airways for ensuring that some of the luggage that was delayed for our regional teams made it here on time for yesterday's competition. Now, to the audience. Families, friends, and well-wishers. Your energy and presence have helped make today an unforgettable experience for our students. And to our parents especially, I know that you're very proud today. I want to say a special word to our parents. I want to encourage you to keep encouraging your young children to take advantage of opportunities like these because you never know what doors they will open, and I speak from experience. Now, to the powerhouse behind it all, our directors who work tirelessly around the clock to ensure that we were here today. Mr. Curtis Cornelius, Ms. Janice St. Romain, and Mr. Kimar Roberts. I thank you for your work. This is, of course, is always a labor of love, and I'm extremely proud of what we have accomplished together. To our two finalist teams and to our winning team, you have earned your place in this final courtroom moment. Now, regardless of who lifted the trophy today, know this. All of you, both teams, have already won something very powerful. the confidence that you can stand in the highest courts of the region, or of this country, and be heard and be acknowledged. So as we close today, let us all leave with a renewed commitment to cultivating young leaders, to pushing the boundaries of excellence, and to building a stronger Caribbean, one advocate at a time. Thank you. May it please this honorable court. And now for the wonderful part where we actually give prizes to the teams who have worked so hard. I will ask my colleague director to help me with distributing some of the prizes. One second. And so at this juncture, we would like to express gratitude to our judges, because without our judges, we would not have had such a spirited moot this afternoon. And so I would like to first invite the Honorable Dane Hamilton to receive a token of the association's symbolism of our gratitude to you this afternoon, or this morning. Can we give him a round of applause for his support to our students? And also now to Mrs. Shannon Jones-Gittins, the Acting Director of Public Prosecutions, for your role and your commitment over the years to ensuring that our students are always kept at the highest standard. And to round up our judging panel, Ms. Rillis Adams, Crown Counsel in the Office of the Director of Public Prosecutions, again for your commitment to students and legal education in Antigua and Barbuda. Now, I think at the start of the competition, Janice St. Romain would have explained that how the competition works is not only your advocacy, but also your written skills. So a memorial was written, and that memorial would have enabled the teams to advance to the semifinal rounds. And so every year, we give an award for the best memorial. And this year, the team that will be awarded the best memorial is Team 108 for the respondents, Miss Cece Lewis and Miss Amaya Guinness. Now, the next prize is for the best advocate in the final round. We want to, of course, take note and acknowledge your skills that you displayed today. And that person is Jessica Samuel from the Appellants, Team 101. Now, as previously mentioned, 3 academic institutions took part in the competition this year: the Antigua State College, the St. Vincent Community College, and the T.A. Marichaud Community College. And each year, we give an award for Best Academic Institution. This year, the award goes to the T.A. Marichaud Community College. We would like each member to come because we have a prize for each member. So can each member come up because we have a prize for each of you? Oh, let me go back. Just stay in the middle. Most Promising Advocate. This is presented to the team member whose performance in the competition demonstrated exceptional potential in legal advocacy. This award recognizes emerging talent, strong analytical thinking, courtroom presence, and a clear trajectory toward future excellence in the legal field. And the recipients of that award today is Miss Adia Daniel of the St. Vincent and Grenadines Community College, and Miss Adahara Salfali from the T.A. Marichaud Community College. Now, our finalist teams have really displayed a high level of intellect today, and it was an amazing competition. To our second place team, we want to honor you by giving you a prize of $2,000 from the National Mooting Association of Antigua and Barbuda, and of course, from our sponsors. And so would you come up here, please, to collect your prize and also your certificates. And now to honor the winners of the Fortis Advocatus Moot Court competition, Team 101, Miss Jessica Samuel and Miss Oceanique Joseph, who will be receiving a cash prize of $3,000. And also, we would like to announce that the Prime Minister's Scholarship Committee, represented today by the chairman of the Prime Minister's Scholarship Committee, Mr. Maurice Merchant, has graciously agreed to sponsor full tuition for both students to pursue their legal education at the UE upon graduating, of course, from the Antigua State College. And so I think that this is an awesome commitment to legal education in Antigua and Barbuda and fostering excellence. I would like to invite Mr. Maurice Merchant, the chairman of the Prime Minister's Scholarship Committee, to take a picture with our students. Thank you so much. And remain Team 101. We also will present you with your winning plaque, which will be displayed at the Antigua State College for the entire year until someone else takes up the mantle. Now, of course, in the spirit of regional integration, we are always very pleased to have our regional academic institutions participate. And so we would like to give you a token of our appreciation for visiting our shores in Antigua and Barbuda for those of you who have been here for the first time. And I do hope that you return. Curtis, also can we have all of our regional participants so that we can give you a small token of our appreciation? We will also be presenting our semi-finalist certificates for those who would have advanced to our regional participants. So at first, we have Cameron Sincere from the T.A. Marisho Community College. And next is Eloise Mitchell Gooding, also from the T.A. Marisho Community College. Miss Adia Daniel from the St. Vincent Community College. Miss Adahara Salfarli from the T.A. Marisho Community College. Miss Abia Telesford from the T.A. Marisho Community College. Mr. Chaz Kelzer from the St. Vincent Community College. And now we would like to honor our regional coaches. Two of them are present today. And so that is Ms. Danish Harford and Ms. Cherise Noel from the T.A. Marisho Community College. And also to Ms. Akila Southwell, we also have a token of appreciation for you. And given that today is a very exciting day for you today because you would have coached the winning team into excellence. So thank you so much for your dedication. So I do believe that concludes our prize-giving ceremony. I omitted to include the fact that our volunteer, Ms. Kioja, who has actually a past mooter of ours and has always committed to assisting us with anything that we do. So I want to say, Kioja, thank you so much. And with that, we have officially come to the close of the 2025 Fortis Advocatus Moot Court Competition. Thank you to everyone. We are extremely blessed, and have a safe day.